And one is Manoj, integration. So that can't be touched. If part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched. C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched.
Why now your lordships have, in fact, may I tell your lordship something interesting, because I looked at the original constitution of India. The friend will show it to your lordship. It was only a marginal note. It's not the heading of 370. Let me preface my submission by saying this, that there were substantive provisions of the Constitution of India that were to be made applicable to Jammu and Kashmir. The directive principles of state policy, or even 356. These were all done through the application order. So that's the power under D, with consent, with concurrence. Take fundamental rights. That's nothing to do with the lists, Manoj. With 371, B1 and 2 talks of the lists. By law, particular lists. Instrument of accession, only those 4 items. That's B1. B2, other lists. That only refers to lists. That's 370. Then you come to, Manoj, the application of constitutional orders to Jammu and Kashmir. Now, any law passed under the lists, if it relates to, Manoj, instrument of accession, consultation. If it relates to other things, concurrence. But substantive provisions of the Constitution were made applicable, Manoj. That also with concurrence. And this was being done between 1951 and 1957, when the Constitution came into force. Then the Constitution took over.
This was between 1951 and 1957.
After that also there were application orders. Because 371D, Manoj, continued in operation. So that's why I want to show you the 1954 constitutional order, which superseded the 1950 order. And it will show, Manoj, what was done. So nothing was ever done without concurrence, except, Manoj, for those 4 items. Never, till date.
Mr. Sibal, why is it that, what is the distinction between the consultation with the government of the state, which is referred to in the first proviso to D, and in clause 1 of B? Because clause 1 of B also refers to consultation with the government of the state, and the first proviso to D also refers to consultation with the government of the state. So it can be a surplusage. There has to be a meaning for why there's 2 separate provisions in relation to the same.
I must explain that. Because if you look at Manoj B1, it says make law. It's not in relation to the same thing. So it says make law with respect. So it only deals with the lists. If it comes to instrument of accession, those 4 items.
Actually, I was looking at it this way possibly. I mean, this thinking aloud, maybe wrong, correct me if I'm wrong. B1 refers to the specification of matters,
yes,
on which are covered by the instrument of accession,
yes,
in respect of which Parliament can make laws. That is B1.
Correct.
It refers only to the specification of matters in the union list, which are covered by the instrument of accession, on which Parliament would have the lawmaking authority. That is B1.
Absolutely.
Now, the first proviso to D would obviously not cover that category. Otherwise, there was no need to put the first proviso there.
Well, those only.
Just see, just one second.
I'm sorry.
See, the first proviso also says, provided that no such order which relates to the matters specified in the instrument of accession of the state referred to in para 1 of subclause B shall be issued except in consultation with the government of the state. So the first proviso also refers to the matters covered in clause 1 of B. It also refers to consultation, and B1 also refers to consultation. Now, possibly the meaning which can be attributed to the proviso to D is this. D says, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may make. So, where the President is making an exception or modification to another provision of the constitution, then the President has been given the power. But what the proviso says is, the first proviso says that if the President is making a modification or adaptation in respect of a matter which is referred to in clause 1 of B, namely something covered by the instrument of accession, then you require consultation. The second proviso then says that no such order which relates to matters other than those referred to in the last paragraph will be made except with the concurrence. I was wondering, just thinking aloud, what D says is that if the president is making an exception or modification in the application of any provision of the constitution to the state of Jammu and Kashmir, then you require either a consultation, first proviso, or a concurrence in terms of the second proviso, right? Now, what happens if the president is not making any exception or modification at all? Does that require either a consultation or a concurrence?
Yes, Manoj, according to me, yes, but let me explain.
Because this adaptation order which you showed us, for instance, of 1954 makes modifications. Preamble will apply subject to these exceptions. Directive principles will apply subject to these exceptions. But what happens if the president is not making any exception or modification at all? Then do you require a consultation or modification in terms of clause D?
May I, Manoj, then?
Yes.
Manoj, since you're
Yes.
Now, Manoj, kindly look at B1 first. It says the power of parliament to make laws for the said state shall be limited to matters in the union list and in the concurrent list. It doesn't say anything more than that. It specifies the lists under which they can make laws.
Which?
Again, no, that's right. The law has not yet been made. This is only the power.
Are declared by the instrument of accession.
So, Manoj, only the list, communication.
Right.
I'm not talking about, the law has not yet been made.
No.
So they are correlating the making of the law to the items in the lists. When it comes to the instrument of accession, it has those 4 items. When it comes to other matters, it is in the concurrent list, not in the state list. But they are not setting out, Manoj, what law is to be.
One very important thing is that clause B does not confer the power upon parliament to enact law for the state of Jammu and Kashmir. It limits it in certain respects. The power of parliament to enact law is under 245 and 246.
246 will not apply.
No, but the power is somewhere else apart from B.
No, Manoj, I'll come.
B recognizes the power of parliament to enact a law because it says the power of parliament to make laws for the state shall be limited. It's a limitation.
No, it's a limitation.
But Justice Paul also says that it's a limiting clause.
Yes, square that list only means square that list.
So if it were a limiting clause, the power of parliament to enact the law is traceable elsewhere.
No, Manoj.
Can we say that 370B gives power to parliament to enact law? No. It limits the power of parliament to enact law to a certain extent.
I was trying to explain what
Yes.
not put to me. Please allow me. But
Yes.
what I was trying to say was that here, what the clause says is that where the lists in the instrument of accession, right? Parliament may make a law, but that will be in consultation.
It's a double limitation, Mr. Sibal. See, the first limitation is the chief mentioned.
let's-
Power of parliament to make laws for the state shall be limited to.
Yes.
What is it limited to? To matters in the union list
Yes.
and concurrent list. So first part is matters in union and concurrent.
Correct.
But second qualification, which in consultation with the government of state, there also you are right, to that extent you are right, it is in consultation with government of state, are declared by president to correspond to matters specified in the instrument of accession
Correct.
governing the accession of the state.
Correct.
So such parts of union list and concurrent list which form a part of the instrument of accession, because everything else doesn't form a part of the instrument of
Correct.
accession. The whole list doesn't.
Right.
To that extent, Parliament can enact
Law.
Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely. Right.
That's how I read it.
But that's what I'm saying too. But they are not, at that moment, the law is not made. They are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those 4 items: communications, defense, external affairs, and ancillary, which I showed to your lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Manoj. That's how I'm trying.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Millard's 1 is integration into India, and Millard's the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. We're talking about preamble, we're talking about 356, we are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read, provided that no such order, that is no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your Lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference. It's entirely different.
Yes, much.
So, Attorney General, that too, constitutional practice is one thing. We're now looking at just the text of the provision. There are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than 1 and
2.
1 and
Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is, even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction?
I come to that. But actually, if your Lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice said constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render 3 OCOs completely. C will become OCOs.
C is
the provisions of the Constitution.
The C is something different. C dilutes the article itself.
C, Madhurs, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Madhurs. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And 1 is Madhurs integration. So that can't be touched. If part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched.
Interpretation.
C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. Just say that.
By now, your lordships have, in fact, may I tell your lordship something interesting? Because I looked at the original constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 37.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. You can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done.